with any substantive, any important legal document that you're being asked to sign, you need to read it, you need to understand it, you need to be fully conscious of the obligations that you are taking on before you sign a contract. Contractors must keep themselves up to date with what's going on the website, because these changes are coming on a monthly basis. It may not always be a change to the contract, it might be a change to the invitation to tender, it might be a change to a model form, it might be a change to the form of tender or schedule, but these changes are coming at a rapid rate. Meet the deadlines and proactively engage in the procedures. There are advantages in the changes to the claims procedure as I've identified. I think that it will result in cash flow easing. I think it will result in claims being dealt with expeditiously by employers' representatives. It will also hail the end of the mopping up exercise that has been the final account negotiation. But we anticipated 5 years ago that that would disappear. I think this is just a further nail in the coffin for that particular exercise. I think that employers' representatives will have to engage with you, because if not, you're going to be involved in serial conciliations which will distract heavily from what's going on in the project and actually bring the thing to completion. If you don't engage, if you don't meet deadlines, if you don't adhere to the procedures and the timelines that are set out, it is the contractor who runs the risk. It is the contractor who runs the risk of losing out on opportunities to claim, of losing out on actual legal entitlements under the contract. And again, every time I talk about this contract, I re-emphasise the fact that compliance with 10.3 is not optional. You must comply with both sides of the notice requirements. Notify of the claim and provide the additional information within the timelines. If you don't, you will lose the right to claim. The default position in these contracts is specifically designed to suit the employer. There's no getting away from it. So every time you fail to comply with a procedure, the employer will not suffer. You will. Very reluctantly, I say that I don't think there will ever be any judicial interpretation of these contracts. And the reason I say that is that every dispute which arises under these contracts is required to be referred first to conciliation and then to arbitration. With the new provisions of the Arbitration Act in respect of costs and the introduction of that cost element into these contracts, very few contractors will be prepared to take a dispute to arbitration. Even if they do so, arbitration is private litigation. And as a result of other provisions of the Arbitration Act, the decisions and awards of arbitrators will very, very rarely end up in front of a judge. It is highly unlikely that any of these clauses of these contracts will ever end up in front of a judge. Therefore, we have to take them at face value. We have to purposely and purposefully understand and interpret every single clause of these contracts, because we're not going to get judicial guidance in relation to them. I hope I'm wrong. I hope that somehow these contracts end up in front of a judge somewhere and we get a full judicial interpretation of some of these clauses. But for the moment, and we're 5 years into this process at this stage, there hasn't been one court decision in Ireland in relation to any of these contracts. And I think it's unlikely, in view of the Arbitration Act, it is unlikely that that will occur. The arbitration cost provision, I just want to re-emphasise how important it is that everybody consciously makes a decision as to whether or not they're going to be bound by that clause. And if you decide you're not going to be bound by that clause, you must do so in the full knowledge that by rejecting it, you are putting yourself in a position where your tender itself may be rejected. You'll be aware of the Construction Contracts Bill, which is currently before the Dáil. In the regulatory impact analysis of that particular bill, which is where the government department actually looked at it in full view to see whether or not, what amendments were appropriate to make into it. One of the observations they made was that because of the provisions of the 2010 Act, the contracting authorities are now in a position to make sure that each party to an arbitration will bear their own costs. Not that the parties can make that decision, which is what the Arbitration Act says, but that the contracting authorities are taking full advantage of that particular provision. This is a deliberate and considered introduction into your contracts. I am very concerned about the manner in which these changes are introduced to the industry. As I said at the very outset, if a change was going to be made to the GDLA form of contract, it was heralded, it was announced, it was notified. These changes are introduced without discussion, without consultation, without notification in a lot of cases. The only notification is through the website. And if you look at the news items and if you look at the changes to the contract, you will see a 1 or 2 line explanation of the change that has been introduced, which you then have to go and look for in the document. It's not highlighted in any way. There is no consultation. Don't be under any illusion. None of these changes have been brought about through consultation with the industry or consultation with the architects or the engineers. These changes are simply introduced and are there to be absorbed by the industry. The web-based nature of these contracts facilitates that type of procedure. I would urge, as I've already said, constant vigilance. You need to be checking this website on a regular basis. You need to check every single time you submit a tender. You need to check what form of contract has been specified for use with your tender, because the form of contract used will determine whether or not you're impacted by these changes. The other thing I would draw to your attention is that we are operating in a completely new environment, as we're all aware, but this is a completely new contractual environment. All claims information would appear to be gathered centrally. There's a specific requirement in the arbitration rules which says that every award made by an arbitrator in a dispute arising under these contracts, because these arbitration rules are specific to these contracts, must be submitted to the Department of Finance within 14 days of the making of the award. Arbitration is private litigation, but these rules require that the arbitrator, who is a private judge, must submit his award to a third party, being the Department of Finance, within 14 days of making the award. Under the old system, different claims, different contractors, different contracts, and different employers would result in different results for contractors and employers' organisations all over the country. Now what we're finding is that although you are still different contractors operating in every corner of the country, doing different projects and different types of projects, it would appear that the information in respect of substantial claims anyway is being pooled. I can't see any other reason for the type of amendments we've discussed today. And it is my view that today's successful claims, in particular the substantial ones, will result in tomorrow's amendments. That's it, gentlemen. Thank you.